You are live. Good morning, everyone. Sorry for the slight delay with weather and stuff, waiting for folks to be available. And so we have a quorum for this meeting. Welcome to Lcar's meeting on December 5, 2024. And before we get going here, let's do introductions around the table. We'll start with Ledge Counsel here.
Good morning, I'm Damian Leonard from the Office of Legislative Counsel.
And I'm Representative Mark Higley from the Orleans-Lamoille District.
I'm Senator Chris Bray from the Addison Senate District.
I'm Mark McDonald from the Orange County District. Trevor Swirl, I represent Underhill and Jericho. And on Zoom, Jenny, you want to go?
Sure. Senator Jenny Lyons representing Chittenden Southeast.
David?
Good morning, Senator David Weeks, representing Rutland County.
Okay. And first order of business of the minutes from October 31. Have a motion.
Minutes of October 31 meeting.
Okay, we have a motion to approve. Any discussion? Edits, comments? Seeing none, all those in favor, please say aye.
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 Opposed? Okay, thank you. First rule up is 24P23, Department of Mental Health. Rules for administration of non-emergency and voluntary psychiatric medications. And Karen Barber is going to speak for the department. But before we do that, I want to apologize for our administrative staff for not allowing them to introduce themselves.
Charlene Dino, outgoing committee assistant.
She's been saying that for a long time. And we have a new,
Emery Mathias, incoming committee assistant.
and we have our high-level support team here.
Mike Broad, Director of Legislative Operations, trying to make this transition happen finally.
Okay. Thank you. Karen, you're up.
Good morning. My name is Karen Barber, and I am General Counsel of the Department of Mental Health. Today, I am here to talk to you about our proposed changes to the rule on the administration of non-emergency involuntary psychiatric medication. Before I get into the changes, I just wanted to take a step back and first frame what we're talking about, and then talk about the original rule. So first off, what are non-emergency medications? So what we're talking about with this rule are court-ordered long-acting psychotropic and voluntary medications. So the process for applying for and being granted involuntary medications is a court process that's set out in Title 18. This is different from emergency medications. So those are medications given during a seclusion or restraint. They do not require a court order. They are short-acting, and they're meant to help in the moment kind of calm the individual. And those are governed by a different rule. That's the regulation governing emergency and voluntary procedures. And I think it's important to also remember that on top of both of these rules and the statutes, there's additional oversight and regulation. So all hospitals are licensed by the Vermont Department of Health. In addition, their CMS, Centers for Medicare and Medicaid Services, certified and Joint Commission accredited, meaning that there are strict quality standards that must be followed that also kind of play into the administration of medication. In addition, individuals receiving or actually giving the medications are licensed, so they're all overseen by their own individual professional boards. So given all that regulation, why did we need a rule in the first place? So what the rule does is it helps flesh out the process around giving non-emergency medications, and it gives additional due process requirements above what is required at the federal level. So the rule sets up processes for allowing for the notification of the individual of the court order and making sure they have time to speak to their attorney and their treatment team. The rule describes what must happen before, during, and after the administration of medications, including a support person. The rule specifies where we can give medications, which is the basis of the change. It talks about when restraints can be used, and it talks about compliance and enforcement. So why did we make changes to the rule? The biggest reason we made changes to the rule is because you asked us to. So first in Act 27 of 2023, and then again in Act 137 of 2024. And I'll get into that in a minute, but also I just want to note, this is an old rule. It's from 1999 originally. So we also used the opportunity, you asked us to change very specific things, but we did use the opportunity to update it to make the language more inclusive. So what are the changes? So as you can see, if you look through the red line version, there's nothing overly substantive that we changed, other than adding locations to where we can do this. We did change the name of our department because back in 1999, we were called something different, and we added the new authority to change it. The biggest change is what we call designated facilities, which means where we can administer non-emergency medications. Originally in Act 27, we were requested to include a forensic facility. And then in Act 137 of last year, we were given permission to also do involuntary medications at River Valley. So we added both a forensic facility and then other facilities designated by statute, which would include River Valley. We did also add a definition of qualified practitioner. That was something suggested by BOZ, which is the hospital lobbying group. I can't remember the full name of their abbreviation right now, but it's more to be up to date in terms of what medical personnel are on units. It looks a little different now than it did in 1999. So we were simply updating who is providing services. We changed inclusive and person first language throughout. And then the other change we made, which wasn't really a substantive change, although it might look like it, is we took out the section on when you can use seclusion or restraint. And the reason we did that is because in 1999, when this rule was passed, we didn't have a separate administrative rule that governed emergency and voluntary procedures. So basically what this does is take all that language out and references the rule. The rule that was passed on this is much more in depth. So we wanted to make sure that was the rule that was governing. So who did we consult? We solicited input from Vermont Legal Aid, Disability Rights Vermont, the Vermont State Standing Committee, Mad Freedom, VAWS, VCP, which is Vermont Care Partners, the DA group, NAMI, and Vermont Psychiatric Survivors. Of those, we received input from Disability Rights Vermont, the Adult State Standing Committee, Mad Freedom, and VAWS. And we did make changes based on all of their helpful suggestions. After public comment, and we went through Lcar, you can see that we submitted a memo last week or the week before that just has several small technical changes. We did have the opportunity to meet with Katie McLinn, who offered, we talked through a bunch of small technical changes that made sense. So we did submit that memo to you that explains what those small changes were, and then we submitted a new redlined version so you could see those changes. And that's all I had, but happy to answer any questions.
Okay, thank you. Committee, questions? Senator Bray?
Thank you, Ms. Barber. We don't have any witnesses on this other than you scheduled. So is it fair to characterize the idea? Does that represent the fact that all those conversations along the way during notice and comment led to a satisfactory outcome? You're not aware of outstanding concerns?
Yeah, I think the thing to note is that this rule has been in effect and this has been occurring since 1999. So we're not making big changes. The changes we are making based on location were legislative changes. So there was testimony within the legislature. And so no one was like opposed to the changes. I think philosophically, there were some concerns about expanding it, but those were dealt with at the legislature within committee. And so there was no big changes that people suggested.
Thank you. Representative Pickwick.
Mr. Chair, if there's no further questions, I would move that we approve 24P23 Department of Mental Health rules for administration of non-emergency involuntary medication with the proposed modifications submitted by the department in a memorandum dated November 25th, 2024.
Representative Higley has made a motion to approve with the addition of the memorandum on November 25. Any additional comments or questions?
Mr. Chair.
Yes, Senator Weeks.
Yeah, thanks, sir. So if I could, I know this bill or several aspects of the bill passed through the Senate Health and Welfare Committee. And I'm just wondering if our committee chair, Senator Lyons, could at least comment on scope or just general support for the changes. That would go a long way just to, I think, kind of give everybody a bit of comfort.
I'm glad to do that. Thank you, Senator Weeks. And I did send in the cover sheet indicating that these rules meet statutory intent, legislative intent, and certainly with the modifications of November 25th, those actually are pretty important. One of them at least may be seen as non-technical, but they are technical. So I do support the rules as moved by Representative Higley.
And Senator Weeks, Representative Houghton from Chair of House Healthcare also submitted a letter saying that this rule does meet legislative intent.
Okay, well, thank you both.
Okay.
Any other questions or comments? Okay. All those in favor, please say aye.
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 Opposed? Okay, thank you very much.
Thank you.
Thanks, Karen. Okay, next up, we have 24P31, Agency of Human Services, Health Benefits Eligibility and Enrollment Rule, Eligibility Standards. We have three rules, I guess, part 2, part 3, and part 7. We'll need to vote on them separately, but Robin and Danny, I don't know who's going to take the lead on that. Looks like Danny put her video on, so I assume you're taking the lead on this. You can present it as you see fit here. We'll ask questions appropriately, but we will have to vote on them separately.
Yep, good. And this is Robin Chapman speaking. I actually am
Okay.
going to take the lead,
Okay.
if that's all right.
Yep.
Okay, good. But glad that Danny is on with me, and definitely will phone a friend and take advantage of her helping me out as we move this along. But I just introduce myself. I'm Robin Chapman. I am the staff attorney for the Agency of Human Services, Department of Vermont Health Access. Danny Fiacco is the department's senior policy and implementation analyst. And we are here today to present some revisions to the department's health benefits eligibility and enrollment rule, which we call HBEE. Thank you for taking time today to review these revisions with us. As many know, HBEE states the eligibility and enrollment requirements for Medicaid, as well as for enrollment in qualified health plans within the Vermont Health Connect. We come before this committee regularly, starting in 2014 with the Affordable Care Act. We have been doing this rulemaking, and almost on an annual basis, we are reacting to new federal guidance that comes out of changes that our federal partners, CMS, make around the Affordable Care Act. And most recently, there's been a number of changes coming out of CMS tied to COVID, and some questions, issues, resolutions that presented themselves around Medicaid and how eligibility, enrollment, and renewals for Medicaid should be managed as states were unwinding from all the stuff tied to COVID. So that's some of what we're doing here. Just to orient a little bit, HBEE is broken into 8 parts, And today we are presenting revisions on 3 of those parts. They're going to be part 2, part 3, and part 7. And as we said already, we'd like to just present all of those here and understand that there'll be processes separate coming out of that. I also want to mention that the APA pages that accompany each packet that's in front of you are also identical. We do that for administrative efficiency as well as some cost savings at the beginning of rulemaking. A little bit of the timeline on how we got here. We started this rulemaking in July. We pre-filed with Lcar on July 26th. We went before them on August 12th. They approved it. We then filed with the Secretary of State on August 30th. We had a public hearing scheduled and attended that on October 4th, and no one showed up. We then had a public comment period also going at the same time, which ended on October 11th. And we did not get any comments to this particular round of rulemaking. And then, of course, what's in front of you is the final proposed rule, which we filed with this committee and with the Secretary of State on November 5th. I thought I'd take a few minutes to walk through some of the substantive changes, high level, and can certainly do a deeper dive if there's anyone in particular you want to talk about. The first change that is showing up in part 2, and I did try to do these in the order of where they appear, is we have a program that's called Transitional Medical Assistance. And during COVID, we really streamlined the requirements for that as part of our flexibilities that were made available by the feds. And when we came out of COVID, we realized, hey, this works really well. So we presented a state plan amendment to make that a more user-friendly program, which has been approved, and therefore we are adjusting the rule to reflect that. So that's one of the changes. Lots of things deleted in that part, but it really is just to streamline that whole program. We also had a longstanding practice of excluding certain income from individuals that are on our Medicare savings programs. And we learned again through coming out of COVID that we really needed to put that in our state plan, which is what we're doing now, and then therefore have the companion codification of that. One thing that happened in the last couple of years at the federal level is the feds repealed the exception of DACA individuals in the context of qualified health plans. They did not repeal it for purposes of Medicaid. So we wanted to be clear in our rule that the DACA exception only is still in place for Medicaid. So we made that change. Another federal mandate that kind of showed up through COVID is CMS revisited the requirement that individuals have to pursue all sources of income as part of, being found eligible for Medicaid. And CMS concluded that that should be repealed and not require individuals to pursue all sources of income. So the feds repealed it, and so did we. We weren't doing it during COVID anyway, but this is making that, again, codifying what we'd already stopped doing in response to federal direction. Another thing that the feds mandated is that individuals that are on the Social Security Supplemental Security Income Program should be found automatically eligible, not just for Medicaid, but also for QIMBY, which is a Medicare savings program. So we said, yep, we do it already, but we also felt it was important to codify that. So we put that into our rule. And then 2 more that I just want to talk about is another thing that the feds did coming out of COVID was they helped states find ways to streamline and reduce churn with clients. And one of those was to say to the states, when an individual gets denied because they don't cooperate with the process, that we should be giving them 90 days to provide that thing that they weren't cooperating with, and let them reapply without actually doing a new application. We liked it. We started it. We're very early on that one because the feds aren't even requiring states to do it for like 3 years. But we thought, hey, it works. It's helpful. Let's get it into the rule now. So that's also in there. And then the last one that I'll mention is the federal government also told us that we cannot require individuals to have an interview as part of their application process. So they repealed it, and so did we, and put that into effect when the federal law went into effect earlier this year. So that's a mouthful, I know, but it was definitely stuff that we felt was important to get into the rule as soon as we can. There's going to be more coming. You know, CMS did a lot of rulemaking of their own and gave states a pretty long runway to put things into effect. So next year it'll be a little bit of a busier season. But Senator Lyons, I see your hands up. Happy to take a question. Oh, I'm sorry, I can't hear you.
I'm waiting until you're finished, but I wanted to just get my hand up right away.
Oh, okay. Yeah, no,
Yeah.
no worries. Great. I think the other thing I did want to note is in your packet is also a memo. We did need to make a few revisions, technical revisions between the proposed and the final proposed, because the repeal of that pursuit of unearned income, I missed some places where it got cross-referenced and caught it after we'd already filed. So that's really a cleanup to eliminate that concept across the board. And you'll see that memo summarizes that. And that's also why some changes are in that gray highlighting to just call those things out. The last 2 points I just wanted to make was, you know, as part of the APA and process and what we would do anyway, is we looked at fiscal impact, and there is none. You know, as I noted, many of these things we were already doing as we survived COVID and then came out from the unwinding process following COVID. So we did not see any fiscal impact. And as far as public input, as you know, as I'm sure we've all, you know, made clear through all the rulemaking for HBEE, that's really important to us. We need the stakeholder engagement. And this particular round, we did that through the Medicaid Exchange and Advisory Committee, and met with them, shared this with them, and took their feedback through that path. We also posted in our global commitment register. And that's like, you know, anyone can join it. They saw all the revisions we're making. And then was grateful to Jennifer Carby for meeting with us in the last couple of weeks to walk through the changes and talk through things with her. And I see she's on. So Jen, please feel free to chime in. But it felt like we were in a good place coming out of that discussion. And that's the presentation. I don't think I've got more to say other than thank you, and that we would love to see this go into effect January 1, if things are going to be able to move forward.
Senator Lyons?
Yes, well, Mr. Chair, first, if Jennifer Carby has anything to add, that might be more appropriate, and then I'm glad to ask my questions.
Nope. I think I'm good. I appreciate, so Jennifer Carby, Office of Legislative Counsel, but I appreciated the opportunity to meet with Robin and Danny and have them walk me through the changes, and I understood everything. It made sense, and sounds like a lot of it is really conforming with what we're being required to do by the federal government anyway.
Yes, thank you, Jen. I appreciate that.
Senator Lyons?
All right, thank you. My question really is about the timing. CMS, when CMS put some of the rules in place for COVID, was the end of those rules in the original rule? In other words, was it a time limited thing, or did they have to go ahead and make more rules? There's a reason I'm asking this, but
okay. So I think it's thank you for asking, and Danny, please chime in. I think it's a combination. I mean, there were certainly some things that CMS said, hey, look, you know, first, we're going to let you do a few of these things while you are unwinding from COVID. And then during that whole window of time, they talked with states about the effectiveness of it, the usefulness of it. And then they found paths to say, hey, we think we can make some of these permanent. The one example on that would be the pursuit of unearned income repeal. They were like, hey, states took it as a flexibility because it reduced churn. CMS did their own deep dive into their federal regs and they said, we're going to make this permanent. And then they wrote the rule back in April to repeal that and get it off the books. Other things that they also gave us permission to do during Unwind, they concluded they can't do it through any regulation, but perhaps could provide other paths for states to get an outcome. Maybe it's an amendment to their state plan, maybe it's a process through their verification. And we're exploring all of those as well right now. We're actually in the middle of that, taking a look at what some alternatives might look like once the unwinding ends and these flexibilities expire, sunset. You know, is there a way we can keep them going through some of these new tools? So that's why I probably say it's a hybrid, but happy to then kind of talk through what the next piece of that might be.
Well, no, this is helpful. I mean, my concern obviously is that the things that you're changing are really beneficial to the patient. And it's great to see, honestly, and it helps you administratively in many ways. So
Yes.
My concern is we're going to have a new federal government or administration in January, and what effect, if any, that will have, and how much time it takes for going back and undoing all the good things that are here. So that's something that we probably can talk about going forward. But from my perspective, the rules certainly meet our legislative intent, and I think they do help folks who are on Medicaid.
Yes, thank you. I appreciate those words. We agree. And again, that was part of why we wanted to get some of these things codified while, you know, while we have this opportunity to do it and get well established.
Okay, thank you. We don't need to go any further into that, but I'm sure this will be an ongoing discussion.
Yes.
Yeah.
Yeah, and I just want to add that we did receive memos from Representative Wood, who's chair of House Human Services, and Representative Houghton, who's chair of House Healthcare, supporting these rules. In fact, in that, but they do meet legislative intent. So, Senator Bray.
Thank you, Mr. Chair. Ms. Chapman, you mentioned in your helpful presentation some modest revisions based on conversation, I believe, with Ms. Carby, with Legislative Council. Is that correct? And, you know, I think you had said, well, you had already submitted to Lcar, you had some back and forth with Legislative Council, made further modifications after. And I don't see any kind of, often when that happens, there is a memo documenting any kind of changes subsequent to submission of the rule. And I just wanted to check and make sure we're not missing something like approval of the rule as submitted with further a memorandum dated such and such, codifying additional changes.
I think
Go ahead. I'm sorry. Please.
I was going to say, I don't mean to answer for you, but I think the changes were actually made before talking to Jen, and they're on page 8 of your packet.
Thank you.
Yeah.
Okay. I had to say no. We brought up a memo or something like that.
Is that correct, Robin?
Yes, it is correct. When Jen, Danny and I spoke, nothing came out of that meeting that resulted in any need to change anything that we'd already put together for a packet. The change that I did want to call out was reflective in the memo to Lcar from October 28. And I don't have the packet, but page 8 sounds right. It's the one that says memorandum from Addie, from our deputy commissioner from October 28, is the one that I would think you'd see in the packet.
Yep,
Is
that's
that-
the one
okay.
I'm referring to.
Yeah, perfect.
Yeah,
Thank you.
it's on page 8 of the packet for the part 2 rule. I'm not sure if it's also page 8 for the other packets.
I don't see that.
So I can share my screen and put it up there for folks
Yeah, once
if you want.
Thank you.
Oh, I have to log into the meeting then. That could take a minute, but give me just a second. Oh,
If you can help me find it, I can put my screen up if that's helpful.
here, I'll send you a link.
Okay, I'm looking at one of the packets, but I'm not sure which page 8.
Sure. Yeah, I'll send you the link, Jen, and it is page 8 of the document.
Okay.
So there's
while
the
we're
link.
waiting, I can also confirm that there was nothing that I requested that Diva change during our meeting. So I think their changes were some of the just conforming revisions, additional places in the existing rules where Robin said she had missed a couple of strikeouts, which is certainly something Damien and I are familiar with in our work. You can miss some cross references, and that's what she had included in the packet when filed with Lcar.
So these were changes to part 2 and part 7 as I'm reading this, right? Okay.
Yep.
Okay.
Yeah.
Okay.
Yeah, and
It's actually not listed as page 8, but it's after
No.
page 6.
yeah, it's
Of the,
the 8th page in the document. If you go through the front back, I'm looking at the PDF, so it just tells
page
me.
before the adopting page.
Yes. Do you want me to? I do have it now. Do you want me to put it up on the screen? Is that helpful? Or have you moved on?
Do you want her to put it up?
Yeah, please. I'm sorry.
Yeah.
So everyone can see it quickly.
Oh, and I do not have sharing permission.
If I may, this is Danny Fiago with the Department of Vermont Health Access. We also have the list of changes between the proposed and final proposed filing in our public notice in the Global Commitment Register. I put the link in the chat for this, if that's helpful to anyone.
All right, Jen, you're a co-host now.
Right. Here we go.
Yeah, that's the one. Good. Thank you.
Sure. Can you all see this?
Yes.
Would you like me to walk through it or?
I don't think we need to do that.
Okay.
I just want to make sure that we
No, I had.
So your motion will not need to reference this memo because it was in the
packet.
They're included in the language that was sent to the committee.
Okay, is everyone okay?
Yes.
All right.
Yeah.
Thanks, Jen. Okay. I'm sorry, Senator Weeks.
Thank you, Ms. Chapman. I have a couple questions. I'll start. The first one is if you could outline the section which deals with lawfully present for medically or for qualified health plan eligibility. Can you explain DACA exceptions?
Yeah, although I can also bring Danny in if you would like to pick that one up, Danny. I mean, I'm happy to do it too. I just saw you come off mute, so I was like, oh, good. I'll let you handle.
Sure. There was a federal rule that changed the definition of who's considered lawfully present for purposes of qualified health plan eligibility. And the definition change newly includes individuals with deferred action for childhood arrival or DACA recipient status. as being eligible for qualified health plans and the subsidies that folks can receive to help pay for their qualified health plans. The federal rule did not change anything about the definition of lawfully present for purposes of Medicaid eligibility. So there's no Medicaid changes there. DACA individuals are not eligible for Medicaid due to their immigration status, but they can now apply for qualified health plans and receive subsidies.
Okay, so just for clarity, is this a federal requirement or is this a federal recommendation to states?
This is a
Does the
federal
state
change.
have any?
Yeah.
So the state does not have any flexibility in adopting this provision.
No, states have a lot of flexibilities with the Medicaid program, but immigration status is one area that that states do not have flexibilities.
Okay, very good. Thank you. Next question deals with dividend and interest income. Again, is this a federal policy mandated but unfunded, or is this a state, like an option for states to consider?
I'll take that one, Danny, but feel free to chime in. It is an option for states that, because our Medicare savings programs do not have a resource test, we have never counted the income that those resources generated. And we did that for administrative efficiency for years. And very recently, as part of some of the federal regulations, they said, oh, that's great, but you do need to put it into your state plan, that you are not counting that dividend and interest income. So we did a state plan amendment, and then we felt like it seemed appropriate to codify it in our rule so that it was also documented there. So we could count dividend and interest income for resources, but we had made a call years ago not to. And at the time, we thought it was allowable just for administrative efficiency reasons. But we realized from CMS, it's like, no, you got to do a little more than that. So we did.
Okay, thank you. So the resource test is, are you saying that this is potentially being codified because of what we did during COVID, or is this, or was there no resource test prior to COVID?
Prior, we haven't had a resource test specifically for Medicare savings programs. We eliminated the resource test years ago, which was also an option. We took that option years ago. And at the time we took that option, we also presumed, I guess, I don't know, I wasn't here, but kind of said, oh, well, if we're not counting resources for Medicare savings programs, then we shouldn't poke at the interest and dividends those resources earn, because the whole point was to like streamline it a bit. So we didn't, and we haven't for years. And then thinking that that was still administratively appropriate, we never touched it. And then just recently in federal rulemaking, CMS commented on it and said, yes, that's okay that you don't do, but you do need that in your state plan. And that's why we did the state plan amendment and are putting that into our rule to just clarify a long-standing practice.
Okay, thank you. And then if I can, I'd like to discuss for a moment about the budget neutral aspect of the package. Is this budget neutral compared to what we did during the emergency period of COVID, or is this budget neutral compared to the pre-COVID period?
Danny, I'll let you pick that up too, if you don't mind.
So we did not look at the pre-COVID period. So there was the 3 years that we were under a continuous coverage requirement where individuals, except in very rare circumstances, could not be disenrolled. And coming out of that, beneficiary-friendly changes are basically already absorbed into the DIVA budget.
Yeah, that's my question. So it was obviously absorbed into the budget during COVID, and just, from COVID until now. Is it truly budget neutral compared to the pre-COVID period? I mean, I understand that we had an emergency, we did some things to help out a lot of folks. Are we simply codifying what we did during that period, or how does this relate to the pre-COVID period?
Some of these changes are codifying longstanding practices like the one we just talked about with the dividend and interest income. We've excluded resources for Medicare savings programs since 2005. And so that's a longstanding practice. And some of the other provisions had kind of aligned with longstanding practices. And so there's no budget impact to tease out. Things such as their changes to transitional medical assistance were in effect during the COVID period, and I'm not sure that we looked back to the pre-COVID, pre-2020 period for budget impact.
And then I just would also add, and some of them are federally mandated. The repeal of the pursuit of unearned income, the feds basically have said, stop doing it. So, we are under a federal mandate to stop that.
Okay.
Yeah.
But the question is it truly budget neutral? Is it budget neutral compared to what we did during COVID, or is it budget neutral compared to the pre-COVID period? That's really the essence of the question. I understand Danny's response about the article which was changed back in 2005 or what have you. But
yeah,
I'm really looking for effort or not.
I think that we could follow up on that for you. Since I'm not a budget expert by any means, so we could definitely take that one back.
yeah.
Okay, thank you. And the last question is, why was the interview? Why did you deem it acceptable that no interview would be conducted during the application process?
So that was a federal mandate that we discontinue any in-person interviews as part of the Medicaid eligibility process. We already weren't doing them for community Medicaid. The only program that still had an in-person interview, well, by phone, but same concept, was long-term care Medicaid. And CMS mandated that we stop that interviews could not be required. And some of the reasoning, I mean, I think, from my perspective, is people were getting terminated for not attending the interview. And that's part of what I think drove CMS to say, they can voluntarily have an interview and you're glad to offer it up. But to make it a mandate also carries with it a non-cooperation component that would deny somebody's eligibility for not attending one. And I think it's that piece of it that took it out of being a requirement. And, I will say the long-term care unit still offers it as a voluntary thing if it's helpful to the client. It just can't make somebody do it, and it can't deny them if they fail to appear. And that's the key part, is they can't be denied for not attending. And so we took it out of the rule.
Thank you. Thank you very much.
Senator Bray.
Thank you, Mr. Chair. With all that helpful conversation, thank you. I move approval of Rule P31, Agency of Human Services, Health Benefits Eligibility and Enrollment Rule, Eligibility Standards, Part 2.
We have a motion to approve the rule, Part 2. Any questions, comments? Not seeing any. All those in favor, please say aye.
Aye.
Opposed?
Aye.
Senator Bray?
As I understand it, correct me if I'm misunderstanding it, I then also move approval of Rule 24P32, Agency of Human Services, Health Benefits Eligibility and Enrollment Rule, Non-Financial Eligibility Requirements, Part 3.
I have a motion from Senator Bray regarding Rule 24P32. Questions, comments? Not seeing any. All those in favor, please say aye.
Aye.
Opposed?
Nay.
Thank you. Senator Bray?
And to complete collecting the full set, move approval of Rule 24P33, Agency Human Services, Health Benefits Eligibility and Enrollment Rule, Eligibility and Enrollment Procedures, Part 7.
We have a motion, Senator Bray, approve Rule 24P33. Any questions, comments? Seeing none, all those in favor, please say aye.
Aye.
Opposed?
Nay.
Okay, thank you. Okay, thank you, Robin, and thank you, Danny. Appreciate it.
Thank you.
Have a good day. Okay, next up is Rule 24P34, Department of Corrections, marriage ceremony for incarcerated individuals. We have Margaret June Fowler, who is the Policy and Implementation Analyst, Department of Corrections, and David Turner, Facility Operations Manager, DOC. Don't know who's taking the lead on this.
Good afternoon, everyone, and thank you for having us today. My name is Margaret, or MJ Fowler, and I'm a Policy and Implementation Analyst with the Department of Corrections, and I'm here with my colleague Dave, if you would also like to introduce yourself, but I'll take the lead for now.
Yeah, I'm David Turner. I'm an operations manager for the Department of Corrections. I helped with this marriage rule, and I do a lot of stuff with the out-of-state unit, amongst a lot of other things, but that's who I am.
Okay, welcome. Please proceed.
We are here to discuss an amendment to the DOC's marriage ceremony rule. This rule is important to the department because marriage is a constitutional right and a liberty interest for incarcerated individuals. The previous version of this rule, which was adopted in October 2018, included language from 18 VSA 5142, which requires correctional staff to verify the statutory requirements for individuals who are not authorized to marry. There has been a change in 18 VSA 5142, where it now states that all parties must be 18 years of age or older to qualify for marriage. This change promulgated the need for an amendment to the DOC's marriage rule, which stated that individuals 16 and older are able to be married with parental consent. Upon reviewing this rule and the DOC's process, we found that requiring staff to verify the statutory legal requirements for marriage was creating redundant work. The town clerks already performed this verification when they issued a marriage license. Therefore, we propose to remove this redundancy in order to streamline the process. The amended rule will clarify that the department's role is to receive an incarcerated individual's marriage request, assess whether there are any safety or security concerns, as well as evaluate any risks to the incarcerated individual's rehabilitation or any other legitimate penological interests. Once those considerations have been made and the marriage request is approved, the department will proceed with hosting the marriage ceremony, provided the incarcerated individual has submitted the appropriate proof of the marriage license. We believe this amendment will align the department with the current statutory language and make the process more efficient while maintaining the important legal and safety considerations that guide the Department of Corrections decisions. During the public comment period, this final proposed rule was sent out as an all-staff email. It was also posted in all the law libraries and on all the incarcerated individuals' tablets. Incarcerated individuals had the opportunity to comment on this rule by submitting a form to their law library administrator or by putting their form in the facility mailbox. There were no constituents who attended our public hearing on October 15th, and we received no comments during this public comment period. As a result, no changes were made after pre-filing with Lcar and receiving their approval. Please let me know if there's any other information Dave or I can provide, and if there's anything else we can do. Thank you.
Thank you. Representative Hinckley.
Yes, I just have one question, and that's why is it provision that or that it is not required to have a marriage license to be submitted with a request form, but it is required prior to the event. It seems a little bit odd to me that you could have that provision and then have the ceremony set and then still not have that license.
Yeah, so the reasoning for that is because I think marriage licenses are only good for 90 days. So we really wanted to go through the process, make sure that the incarcerated individual would be eligible, and then set a date for them so that their marriage license doesn't expire before the ceremony can be held.
Okay.
Committee members, other questions, comments? Senator Bray.
So Chair, hearing none, I would move that we approve Rule 24P34, Department of Corrections, marriage ceremony for incarcerated individuals.
Motion from Senator Bray to approve Rule 24P34. Any questions, comments? Seeing none, all those in favor, please say aye.
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 Opposed? Okay. Thank you very much.
Thank you all. Have a good
Thank you all.
day.
Ben, thanks for being here.
Just had it in your hand, I didn't have to do anything. That's right.
Next on the agenda is our calendar for 25. I think all of you have received it. If not, it's in your packet. It's on the table, probably in front of you. Is there any discussion of that? We will not be meeting Thursday, January 2nd. And as you know, when we go into session, we meet every Thursday morning. Senator Bray?
Well, are you hoping to get through all 7 rules at the next meeting, or they're just scheduled to that meeting and some will roll on to the 16th?
We have 7 rules. I suspect we may roll some of those depending on circumstances.
Okay. And then I have a question. I don't know how this is worked. I don't know if there's a procedure or
I know where you're going.
Representative Myers, when she left the legislature, continued on an Lcar for maybe a couple months because appointments didn't come through, like an emerita member, but still a regular Lcar member. Senator McDonald and I will be in the same emeritus status.
Yeah.
I don't know how that works and if you sorted that out.
I have not. I don't know if our Ledge Council has any perspective on that. I agree that folks, I remember Linda Myers staying on. We have a situation with Senator McDonald and yourself, and then of course Representative Bongartz is now Senator Bongartz. So he would not be eligible for this committee. It's the same way, right? So which puts us at risk quorum, which is one person not being there. So I suspect that we'll clarify. We'll certainly clarify, but I suspect that this committee will stay whole until new folks are approved.
Yeah, let me chime in a little bit.
You know the answer to this.
Well, I don't, I'm going to give an answer that I think is accurate, but it stands to be demonstrated, that you're appointed until you're replaced. So that would mean that Senator Bray, Senator McDonald would continue. The issue around the new Senator Bongartz is interesting. So it will put pressure on the Committee on Committees in the Senate and then the House Speaker to make appointments. But it is my understanding that folks would continue until another appointment is made. And that, I mean, that's similar for things like the Champlain Advisory Committee and other, other joint committees. So I would think I'm answering this from just my sort of common knowledge, but I do think we should probably reach out to Senate Secretary or House Clerk and have some clarification.
Yeah, so if I may, the statute provides for a 2-year term ending on February 1 of the odd number year following the next odd number year after you are appointed. So So Representative and soon to be Senator Bongartz and both of you would continue serving on until February 1. But we should get clarification from the secretary and the House clerk regarding what happens if an appointment is not made by then. And that's I think the biggest question, because the statute is actually silent on that. And usually we write in, shall continue serving until their successor is appointed. But this specifically says term ends February 1. So what I would say is at this point, expect to serve through February 1. But we'll get clarification from the secretary and House clerk.
And I'll leave that with you.
Yes,
Okay.
I'll reach out to them and just find out what happens if appointments aren't made. And I can also check the joint rules speak to remote meetings and the joint resolution. And that I think is another question there. So Betsy Ann emailed me 2 days ago regarding that. Just pull up that email to get the language. So under JRH 7, that applies through the remainder of calendar year 2024. So my expectation would be that we may get another joint resolution, but that's depending on time regarding remote participation in calendar year 2025 for joint committees, because that would allow you to participate remotely and not have to make the trip to the State House.
But right now, absent that new resolution, that does not apply.
Right, absent new resolution. So that's something that I'll follow up with them as well to see if we're expecting a rule update at that point. And then, of course, there's always just the question of quorum. If there is a quorum, then it's up to you whether you come in and continue to participate. So just being mindful that it's a long drive if you're not here anyway. So.
Right. But it's the best subject matter of going in the building, so.
These meetings are always exciting, always interesting. It's a reason to get up early on Thursdays. So.
It makes it hard to go to sleep on Wednesday night.
Speak for yourself.
All right, do we need a motion on the new calendar?
That's a good question. Charlene, do we usually have a motion on it?
That's probably a good idea.
Can't hurt. So
we make a motion.
Looking for motion then to adopt the calendar, including the next meeting being January 9 of 2025, commencing with Rule 2445.
Okay, we have a motion. Senator Weeks.
Yeah, just a clarification. So what I think I heard was January 9, but with no meeting on December 12 or December 26. Is that correct?
That's correct.
Okay, thank you.
Any other questions, comments? Okay, we have a motion to approve the calendar with those changes. All those in favor, please say aye. Aye.
Aye.
Opposed? Okay, thank you for that. And I just, before we close the meeting, not knowing exactly what's going to happen in January, I would like to say thank you to Senator McDonald and to Senator Bray for your work and energy regarding this committee. And you guys were here a long time before I was here. Okay, and I appreciate that. And we'll certainly miss that institutional knowledge for sure. Mark, Senator McDonald and I had very interesting conversations Thursday morning before we get here. He shares some historical perspective on where we're going, and I appreciate that. I appreciate both your work on this. Thank you very much.
Thank you, Mr. Chair, and Senator Weeks, thank you for your kind note of a couple of weeks ago.
Okay, thank you. With that, meeting's adjourned. Thank you very much.